or selling a home is one of the biggest financial decisions you'll ever make. But most people don't actually understand what their real estate lawyer is doing behind the scenes. Today's episode is all about what really happens from your offer to closing date and everything in between. And trust me, this is the stuff that can save you thousands. Welcome back. I'm Tracy Mullin, and today we're joined by Jason Lane. Jason is a real estate lawyer with Wojcik Polsonelli, helping buyers, sellers, and investors navigate everything from residential purchases to commercial deals. He's a Durham regional local boy, called to the bar in 2020, and someone who sees what really happens behind the scenes of a real estate transaction. Jason, thanks for joining me today.
Oh, my pleasure. Thanks so much for having me today.
No problem. I'm hoping that we can just really help people get a really good feel for what happens behind the scenes of a transaction, because I get a lot of questions, even with regards to the deposit. People seem to be confused as to where the deposit goes. So we actually, as realtors, the deposit usually gets held in trust by our brokerage. But sometimes it does get held in trust by the lawyers, correct?
Yeah, sometimes. So as you said, most of the time it's being held by the listing brokerage or the selling brokerage, but more when there's private agreements. So if one party doesn't have a realtor, then yes, we will hold the deposit in trust. And again, that's only being dispersed upon the completion of the transaction. But in most cases, it's with the realtor.
Right. Well, I always joke with my clients. I always say, we've got the deposit, and don't worry, I'm not going to go shopping, because you do wonder what happens to this deposit. But what about what happened with iPro recently, where they had spent more than $10 or $12 million? Should that be a concern for the public?
I would say that not generally. So to be specific, what's happening with the deposit is it's going into the brokerage's trust account. So it's required to go into a trust account, and that is separate from a brokerage's general spending account. So that trust account, creditors don't have access to that. People suing the brokerage or whatever, it is protected from anything like that. And all brokerages, they're actually required to have insurance for these accounts as well. So that specifically, in most all cases, shouldn't really be a concern for buyers. And also another thing that a lot of buyers may not know or not fully understand is when you give that deposit, there is no way for the seller to get access to that deposit unless the transaction completes. There's a mutual agreement between the two of you. So you agree to get the deposit back or give some to the seller, or there's a court order. So there's no way for that deposit to just arbitrarily be given to the sellers. It is protected, and you're going to be fully aware of what's happening with it.
Right. That's an interesting statement, because one of the biggest concerns that I hear from buyers is, well, what happens if I don't want to complete on the transaction? So if it's a conditional period, will I get my money back?
Yeah. So and during the conditional period, certainly that's what that conditional period is there for. So when we're talking about a conditional period, most often we're talking about either a period to confirm you have the appropriate financing or a home inspection. So if you get to the end of that conditional period, it really doesn't look like you can proceed with this transaction. All of those condition clauses explicitly state that the deposit is to be returned. And even if it didn't say that, basically if a condition isn't fulfilled in time, the whole transaction becomes what's called null and void. It's a dead deal, and that deposit is owed back to the buyer. Now, in saying that, technically that doesn't automatically happen until there is a release where both parties agree, yep, we're done with. But the buyer can be confident in knowing that the legal position they have is that they are entitled to the return of their deposit.
Right. A few years ago, we had a lot of problems with people firming up on transactions based on their mortgage pre-approval, and then not completing on the transaction because at the end of the day, the house didn't appraise just before closing. That's caused a lot of concern for people. Can you speak to that?
Yeah, and that's less common for resales, but that's still actually happening quite a lot on new build transactions. The problem, especially that we're having previously, is in the past there's been periods in the market where a lot of people are going firm on transactions. They're not putting these conditions in. They think they have this pre-approval, they're good to go, and then it turns out they're not. The appraisal's low, they're short, let's say $100,000. They have no way to get that. The problem there is that all transactions in Ontario, like the standard agreement, there's a clause that says time is of the essence. So this must be completed on the closing date. If you don't complete it on the closing date, you're technically in breach of contract and you stand to lose that deposit. If the seller wants to go relist and resell the property, they have the right to do that. So that's just speaking again to the importance of, if it's at all possible in the market to have those conditions, it is really important, because if you're going in firm just on a pre-approval, there's a chance you don't have financing available and you stand to lose your deposit and possibly more through litigation.
Well, that's one of the things I'm always talking to people about. Like, they'll say, oh, they can go firm because they have a house and they have no mortgage on it. I'll be like, or they have a small mortgage. I'll be like, yes, but what happens if, you don't sell your home? You have to think about all of the contingency plans and put those in place to start with. And they'll be like, well, I'll just, bridge finance. I go, well, you can't bridge finance without a firm sale. So that's how people, sometimes they don't get good advice, or I'll be like, call your lawyer. They're always waiting till the last minute. They think they can handle it and figure things out. That's what I'm finding in this market. People are just thinking they can handle it. Even you talked about the new builds a second ago. Yep. Do you know how many people are closing on houses this summer that can't close on the house? And they think, oh, I'll just go and get an extension from the builder. Why would the builder give you an extension, right?
Yeah. Builders are not renowned for their kindness typically.
Yeah.
They're business people, and if they stand to lose something, through that contract, they're not going to let you just extend for free. Mm-hmm. Those, and specifically new build contracts, it's not even a standard form agreement. It's a very specific agreement that the builder's lawyer drafts, so it's very to the benefit of the builder. And yes, they are under no obligation in almost any circumstance to grant you an extension. So it is critical with the especially with the new builds, that you're aware of what the requirements are going to be, and that you stand to be in a position to close, because if they do grant you an extension, it's probably going to cost you quite a bit as well.
Right.
They usually charge quite a bit of fees
to
do it.
Well, I can't believe how many people even right now, and no judgment, but call somebody that you trust before trying to figure it all out. Right now, we're getting a lot of people with second mortgages who are trying to hold on to property because of course, it's your home in most cases, and it's very important, but you've gone and you bought something else new, so you kind of have to make a plan. And calling your realtor first to help you develop a plan is a good starting point, or call your lawyer. Call somebody
Absolutely.
that knows more than you know.
Yeah.
Right.
Yeah. Because, you're going to have situations where, you think you know what you're doing, but maybe there's a better option. Maybe there's a better alternative. A realtor or a lawyer is going to know a potential solution you haven't thought of yet, or just concerns in general of what could happen.
Right.
If you're in those situations where it looks like you're going to have to navigate some complications, absolutely, you want to be, connecting with your lawyer, connecting with your realtor right from the outset, so that you don't have any of these surprises that can be very costly at the end of the day.
Right. Let's just build a plan. It doesn't mean you have to do anything now.
Exactly.
But let's build a plan. Like, I have one person that his second mortgage is due March 1st, and he's already got an extension from them. And now we're here at almost the end of February when we're filming this, and they don't have a plan. And it's really sad to me that people just try to work it out themselves rather than asking for support, asking for help.
Yeah. And being in those situations, let alone the financial burden, it's stressful, of course, for clients too. It's extremely stressful to have that unknown and not be sure what the next step is. You have these resources that you can get this advice, and you can figure out the way forward. So you definitely should be using it, right?
Right. So. Well, we had one client recently that had a first mortgage, a second mortgage, and a third mortgage, and they went on ChatGPT and asked them for advice on what to do, and they said, "Oh, just consolidate your loans." So this lady was going to pay an appraiser to come in, and I think it was like $3,500 to come in and do an appraisal on her property. And I said to her, "But you don't have any equity in your home. This isn't you're going to pay them $3,500, and it's not going to work. Like, there's no equity here." So send her back to the mortgage broker to get a second opinion on that, and then decided that yes, she had to sell her house.
Yeah. And you've raised a great point, just referencing ChatGPT and AI, because I get, and don't get me wrong, AI can be a very valuable tool for clients to use, and can be very helpful. But I get a lot of emails that are, clearly they've been drafted by AI, they've had this information by AI, and the clients are relying on this information effectively over their realtor or their lawyer. And the reality is if that you're not completely familiar with whatever you're asking AI about, you're not going to be giving it a complete prompt at the end of the day. And so you're either not going to understand the right question to ask, or you're not going to understand the answer that it gives you completely, because you don't have the holistic experience of working in that area.
Right.
So yeah, I would definitely say that people are very frequently now over reliant on AI for advice.
Right.
And it's not always going to give you the complete advice that you need.
Right. Because in this case, the piece of the puzzle that was missing for this client was they probably didn't put in that their house was only valued at blank. Yeah. So if you're in the financial field, you understand that, it's usually 80% or 65%, depending on how the banks look at that whole picture.
Exactly.
Right?
Yeah. The AI is only going to give you the answer based on what you ask. And if you don't if you don't give it the full picture or the right context, it's not going to give you a full answer.
Right. Exactly.
Yeah.
Exactly. Yeah. Let's talk a little bit about title search. People are paying now insurance fees, right, for your title insurance.
Yep.
So can you tell us, what are they actually paying for? And is there value in it? I mean, does everybody have to do title insurance first of all?
Yeah. So I'll talk about the title insurance first and kind of go over the title search as well. So what title insurance is doing is, first off, a lawyer, part of what they're doing for you, like when you're buying a property, is they're doing this item called a title search. They're looking at the ownership of the property, seeing what's on title. So seeing what mortgages are there, if there's liens, easements, anything that could become an issue for a new buyer. And there's an exchange between the buyer's lawyer and the seller's lawyer. Buyer's lawyer says, hey, I've found these things on title or these issues. You need to correct them. Mm-hmm. Now, where title insurance steps in that regard is, theoretically, there could be things that affect the property that aren't on a title search. We call these unregistered liens or easements. So if I can't see them on a title search, if they come up later, you may have a claim against the previous seller, but then it's you as the buyer having to deal with them. The title insurance basically steps in and says, if you find any of these issues afterwards, we will completely cover you for them. We will do any litigation required to deal with this. And it's doing additional things too. So before title insurance was the primary way of completing transactions, it was effectively required that everybody gets an up-to-date survey for a contract. Mm-hmm. And that is no longer, there's almost never up-to-date surveys anymore because of title insurance. The easiest example of why that's the case is because title insurance says we will cover any issues that an up-to-date survey would have discovered. So let's say we have a buyer that's looking at a property that has a pool in the backyard. It's right at the back of the property. Let's say in 3 years after they buy it, the neighbor gets a survey, finds out that 3 feet of the pool is actually on their property. They tell you, hey, you got to get rid of this pool. It's on my property. Title insurance will actually step in and they will either purchase the piece of land or physically move the pool, because you would have known about it if you had gotten a survey. And then the other things title insurance is doing, another really big one, is for mortgage fraud. So if once you become the owner, let's say somebody steals your identity, registers a fraudulent mortgage on title, takes the money and runs, if you don't have title insurance, while you may be able to claim that was a fraudulent mortgage, you still now have to go to court to prove that. You have to assert it. You're going to expend tons of money to prove it's not yours, and stress. Exactly. Where title insurance, again, they literally just pay off the mortgage and they do all of that in the background.
So let me ask you a question.
Yeah.
If I own a home and I don't have a mortgage on it, and I have had it, let's say I've had it 10 or 15 years and I don't have a mortgage on it, can I go purchase title insurance for my property?
You can.
Right.
Most people since about probably around 2000 probably have title insurance.
Right.
But you can always do if you're somebody who in that situation has no mortgage, has owned for a long time, you can always ask the lawyer that did the transaction for you, whether you have title insurance if you can't recall from when you did the transaction. And if for some reason that lawyer is not accessible or no longer in practice, you could reach out to myself, for example, and we can basically reach out to all the title insurers to confirm whether there is a policy for that property.
Right. So your title insurance doesn't actually go on your claim, like it's not on your deed or anything like that, where you could just go to a registry office and find it if you had it.
No, you'd have to reach out to the title insurers because they have a specific policy for your name and that address.
Okay.
But yes, if you did that process and it turns out you didn't have title insurance, yes, you can buy a title insurance policy at any time.
Well, I think that's really good for people that are worried about fraud.
Yes,
or worried
exactly.
About,
yeah, because it's still rare, but it does happen. We do have people that have their identity stolen and end up with a mortgage on title. And yes, you can buy title insurance policies. The easiest way to do that is going to be to reach out to a lawyer to help you obtain that policy for your property. And just going back to talking about people actually purchasing, one thing I do want to note is it's technically not required. And as lawyers, we have to tell clients that it's not technically required, but in practice, it is basically required.
Right.
At this point, you're going to be very hard pressed to find a lawyer who will even agree to act for you without title insurance.
Right.
Most lenders require title insurance for the lending. And the reality is if you found a lawyer that was going to do it without it, you would require an up-to-date survey and you would require a full solicitor review on title, which is going to cost you far, far more than the title insurance, which is better coverage for you anyway.
Right.
So it's de facto required.
Right. If a lawyer makes a mistake, not that you ever make a mistake, but if you did, does your title insurance cover that challenge, or is that covered by your...
It would depend on the mistake.
Okay.
If it was a mistake that is impacting your title, then likely you would have insurance coverage. But if you do have a lawyer that has done something negligent or has made a mistake that has cost you, their lawyers have what's called Law Pro, or their own mandatory insurance coverage for errors. So you would have a claim through that, like, claiming similar to RICO, like the obligations that realtors have.
Right.
So you would have a complaint process if your lawyer messes up as well.
Okay.
But yes, there are some instances in which those issues would also be covered by title insurance.
Right. Okay.
Yeah.
And so let's go back to the offer then, the actual agreement of purchase and sale. There is a Schedule A where realtors are adding the conditions into the property that they feel is important for the buyer to have. And sometimes we're being told not to include a clause, like don't include a home inspection. So now what we've done is we've actually added the home inspection and have people initial the crossing off of that to show that we're kind of covering our butts too, to say we've recommended this. But, in the last kind of, I don't know how many years, they've added that clause into the offer that talks about a home inspection. Basically, it's buyer beware. If you chose not to have a home inspection, you can't come back and sue the seller later on. Is there any time where you've seen a new buyer sue the seller without having, like, they didn't have a home inspection? Was there something not disclosed, or?
Yeah, so it's difficult to do. So basically, yes, as you mentioned, by default, all agreements of purchase and sale and just all real estate, the maxim is, in the Latin, is caveat emptor, or buyer beware. Mm-hmm. So unless there's anything specifying otherwise, that's the default, and that's just you are responsible for your own inspections and due diligence. You're basically buying it as is. And the only way that you can overcome that is basically by being able to prove that the seller, there was an issue, they knew about it prior to closing, and they took steps to actively conceal it. So
right.
they took steps to hide it.
Yeah, hide it.
Yeah. And so, one, to know all that is difficult, and then two, to prove it in court, for example, is tremendously difficult in most cases. Mm-hmm. So yes, it is usually a matter of, we'll have clients that it's pretty clear that there's an issue that the sellers knew about. And so what we will do is we will put the seller's lawyer on notice for the buyer, saying, hey, look, we know that, you basically you hid this crack in the foundation.
The neighbor told us. The neighbor told. Usually it's the neighbor told us.
Exactly. The neighbor told us this basement's been flooded, every year for the last 10 years.
Or that we knew. Saw the basement repair people there. Yeah. They love to
give the gossip. Yeah.
Yeah. So tell us about disclosures, though. What kind of things? People are so afraid to tell us when there's something wrong with their property. But I said to a gentleman I spoke to the other day, he was telling me that there is something in his laundry room. And I'm like, well, what is the something? And because I hadn't been there, he was like, well, there's this hole. I'm like, what kind of hole is it? And then I said, well, maybe it's, pests getting in or whatever. I said, well, we need to look at it. and decide whether or not you're going to fix it or we are actually going to disclose it, right? So, and you can do both. You can fix it and disclose, right?
Yeah.
So what are the kinds of things that people are trying to hide? Besides wet basements, that's the obvious one.
Yeah, and that's the most common one.
Yeah.
People have, tried to hide, mold in an attic or just, scratches on a floor. There's this, massive carpet that's too big for a room, like area carpet that just conveniently, perfectly hides a bunch of gouges in the floor, like those types of things.
Right.
I mean, those situations it's tough to navigate those, especially when you're selling as well. Like, what do I need to disclose? And it is not always a straightforward answer. Unfortunately, it is kind of on a case by case basis, depending on the circumstances.
But when in doubt, disclose. If you're a seller and you have something that you're concerned about, just disclose it. And then
and now that can't be an issue going forwards because you told the buyers about it. They know about it. They now can't come back and say anything about it because you told them it exists. They knew about that at the time they entered into the agreement. Mm-hmm. And so yes, absolutely. If you're not sure, the disclosure route is the better route.
Right.
And again, to go into further whether or not you need to disclose something, it's actually, if it's a large enough issue, I would actually advise that somebody talk to a lawyer before deciding whether or not to disclose it if we're talking about a major issue.
Right.
Because it is really case specific whether you need to be disclosing it or not.
Right. I love that. I love that that you're saying talk to a lawyer. Yeah. What about the murders, suicides, and the grow up situation?
The stigma.
What about the stigma associated with that? I mean, obviously, if there is a murder in your home, disclosing it just makes absolute sense if you know about it. But there are incidents where people haven't told their realtor that there was a murder there. I've started Googling every address before I go, just to make sure, do I have all the facts? Yeah.
Yeah. And that's, again, another complicated one because there's no specific legislation determining or law determining that you must disclose that because it's really just stigma of the property.
But again, the neighbor's coming over to tell somebody, did you know that so-and-so, there was a murder here? The neighbor's coming over.
Yeah, and then that's the thing is, regardless of what the legal position is, if somebody finds out about that during the transaction, it's going to massively complicate the transaction.
Right.
Because they're going to assert if they had known about that at the beginning, they wouldn't have proceeded because this is a big issue for them.
Right.
So just disclosing it at the outset, you're not going to have those complications, you're going to be much less stressed throughout the transaction because you don't have this item that you're worried is going to come to light potentially, and now you're going to have to navigate okay, are they legally permitted to refuse to close because I didn't disclose this? Right. Disclosure in every circumstance or almost every circumstance is going to be the better option if it's possible.
Right. And also, I love the fact that you said call your lawyer first. Don't disclose to your agent unless you call your lawyer first and discuss whether or not that is important or not, right?
Yeah. Again, if you're dealing with a large issue like that, like a major stigma, like murder or suicide, or it's a grow up, or another issue that maybe to fully repair is going to exceed $10,000 or something like that, it's definitely something you want to be talking to your lawyer about if you're not certain of how to proceed. Right.
And what about suicides? Is that something that as an agent I need to disclose, or only if they put in the contract that is there anything to disclose? Because people now are writing in, have there been any murders, suicides, or anything we need to be aware of, right?
Exactly. So in Schedule A, like we were talking about before, there are sometimes in offers the clause that says there's no stigma attached to the property. Right. And so, if that clause is there, then certainly you want to be disclosing that. And then past that, again, it's really going to depend on the circumstances because legally, if a whole matter went to court, in most case law, there's, just the fact that there was a suicide at the property isn't sufficient for a seller to say, I'm not closing on this. But that's still, to have to be in that situation where you're going to court about that, you don't want to be in that position in the first place, regardless of what your legal right is. Right. Yeah.
Very good. Yeah. Let's talk about chattels, because a lot of people, there's a lot of arguments and problems after closing date with chattels. So chattels are anything that is movable, right? Like fridge, stove, washer, dryer, if you purchase furniture or whatever, that's all considered a chattel. And a fixture is anything that's actually attached to the property is considered a fixture.
Yeah,
correct?
yeah. And most of the time, like, because can be arguments, about what are chattels and fixtures, but those are the most standard and the most of the time the ones we're thinking about. So usually, chattels, we're talking, stove, washer, dryer. Fixtures, we're talking like furnace, potentially like, mirrors that are affixed in the bathroom or
Right.
like the faucets.
Paper towel holders.
Yeah, yeah.
In the old days, light bulbs were missing all the time.
Oh, yeah. No,
you
it's,
move in, you don't have a light bulb.
yeah. And the things that I have had to write letters about are just hilarious, actually. Like, the shower head's missing. So my buying clients want to, sue them for $500
Right.
because there's a shower head missing. So we can get some pretty crazy stuff that's either there or not there, or too much is left there because they said they'd only leave these chattels. Like, hey, we're only going to leave
These
the
5
washer and
things.
dryer. But then there's furniture that sellers are like, oh, we'll just leave them all this stuff. They'll love it.
They're going to love it that we leave all this stuff. And we're going to leave the paint because we need to.
Yeah.
Like, no, people don't want your paint. So unless you ask, don't leave it. Right?
Exactly. Yeah, that's exactly it. Like, I know you may think you're doing them a favor. They might perceive it completely differently. So if you're going to leave stuff, make sure that they actually want it first.
Right. We had one recently where the buyer was complaining that the people took the bidet that you actually attach to your toilet. And my people were like, well, that's like a personal item. I didn't think anybody would want our bidet, first of all, but it was an issue.
Yeah. Oh, yeah, yeah. Buyers come up with a lot of stuff that they're, unsatisfied with sometimes. But that's the thing, right? Is, you've seen a property and you've, invested a lot of time and you have a certain expectation of the way it's going to be when you get there, and you've spent 3 months imagining this, walking into your new home.
Right.
So I get the stress and frustration that buyers have in a lot of these instances. But what I do usually, if buyers are asking me about, what should I expect when I get into the new home, in my mind, like if I'm going to buy a house, I'm kind of in my mind thinking, okay, you know what? There's going to be $3,000 to $5,000 of things that aren't going to be the way I want.
Yeah.
Just because of how often I've seen the realities of what happens. You and the sellers aren't necessarily going to be on the exact same wavelength of your expectations for what's actually at the property when you get there.
Right.
And I know, as much as that may sound unfair, and again, in those situations, you can still reach out to your lawyer and say, hey, this was not done properly. And of course, I'm happy to correspond with the other side. But the reality is they may just say, too bad, so sad. We don't want to do anything.
Right.
And unless it's, more than $5,000, it's probably not going to be worth you, going to small claims court over.
Right.
Something
Sometimes
like that.
for people, it's the principle. Like, damn it, they shouldn't have done this.
Yeah,
They
yeah.
shouldn't have
Who
left
would do
it like
that?
this.
Yeah.
And it's funny. If the house is kind of dirty when you go through on your walkthrough, it's probably going to be dirty on your closing date, because people call me all the time. Like, they're so pissed off at how dirty the house is left.
Yeah.
And to me, it's shocking, because we've always been told, like, get your house cleaned by a professional cleaner before you leave. Why wouldn't you just do that and have it be fine for people moving in, right? Like, it is already stressful enough, to move.
Well, and that's the thing for sellers is, even if your agreement doesn't say you have to leave it, professionally cleaned or in a clean state.
Yeah.
The reality is, if you're leaving it clean, you're going to have buyers who are a lot happier with the situation, and they're going to be a lot less likely to come after you later for other issues. Because if you leave it dirty, they're angry from the outset. They're going to find every little thing wrong, and they may combine that all into, demanding compensation from you.
Right.
And so just doing that is going to reduce the chances of you having to deal with this transaction after closing.
Right. Like, clean out your sheds. I know it's wintertime, but you've got to clean out your sheds, your basement. Everything should be gone as per the contract. When I don't blame people for getting upset. I wouldn't want to come in and have to remove somebody else's stuff either, right?
Yeah, exactly. And that's the thing, right? Is it's just frustrating, and it's, unfair that you have to do that when you're just trying to move in and enjoy your new home, right?
I can't tell you how many times we've sent handyman over to haul away stuff that was left behind. Probably going to get a lot of calls like, Tracy, get a handyman over here.
Yeah.
But that's the reality of it, is like, we don't want people to have a bad experience either, because then it reflects poorly on, on the service that we gave to our client. Yeah.
Well, and it's like, say, you can only sometimes do so much, but it's exactly, that's where, if someone's not happy in the situation, it usually, ends up being you or I that is reflected upon badly with that. So it helps when we're telling the clients or suggesting like, look, these are important things to do. The buyer is going to be happier. Everyone in the transaction is going to be happier, and you can just be done with this and not have to deal with it anymore, right? So
can we talk about how many people are closing on a Friday and then things aren't going the way they want? And you must get inundated after hours with problems from people moving in on a Friday.
Yeah.
Let's move in on a Thursday or a Wednesday, right?
Yeah, it's always on a Friday.
Yeah.
But the problem, or the larger problem with a Friday is you're right. If there are closing issues, and what those can look like, for example, is the most common is if we have a buyer that their financing isn't completed, or they just haven't quite got that to the finish line yet, and they're needing an extension. Well, if it was on a Thursday and they only needed the one day, well, okay, we can close on Friday now. But if it's a Friday, we can't close until the Monday. And so you're stuck in limbo for these 2 days because you're dealing with the weekend, right?
Right.
Like no funding can happen on those days, and no registration can happen. So yes, there is definitely advantages to avoiding the Friday,
right?
Because of that. And also from just a practical perspective is on Fridays, the reality is that all the people at the bank, all the people at the law offices, they all want to go home.
Right.
And so there's actually, statistically, there's more issues realistically on a Friday because people just, they want to go home. Yeah. That's the unfortunate reality of just how human beings work typically. So yes, I would say avoiding the Friday. And again, 99% of the time, it's not going to be an issue.
Right.
But if you have the flexibility, you can avoid having, longer issues by having it be a Wednesday or Thursday.
Right. Let's talk a little bit about pools, because, people are closing now and they have a pool. The best advice I give people is, if you know you're going to sell, have it professionally closed. So then you can give a piece of paper, say it was professionally closed, it was working on closing. How many times are you dealing with pools in your line of work?
Oh, very often. Yeah. So we get, exactly. What happens is, people buy a house in December. So of course the pool is not even on their minds at the time. And then spring rolls around and, I get a call saying, oh, the liner's ripped, or the pool, like there needs to be professional repairs now. And so it becomes a huge issue because they don't have a working pool. And so for sellers, of course, that means that you have a buyer coming along and saying, look, you didn't close this correctly, and now I have a bunch of costs that I want to sue you for, or I want you to compensate me for, because you said the pool was in good working order, or I bought this expecting the pool to be in good working order. And you're right, if you have that professional receipt and you're providing it to them, that's, in most of those cases, that's going to be what your obligation is in the agreement, is we're going to provide you with the professional report. And then if there are issues in the spring, as a seller, you can say, look, I did my part. I got this professionally done. If you have a problem, you go to the professional because they clearly did something incorrectly.
Right.
And so now the buyer is dealing with the pool company and not dealing with the seller directly.
Right.
So that, for both sides is actually advantageous, because, you're not, as a seller, you're not having to deal with this in the springtime again. And as a buyer, you actually have a pool company like, hey, I have a receipt here. You were supposed to do this correctly, and it's broken now, so please fix it.
Right. Yeah, that's a big one for us, is pools for sure. So one of the things that I am so shocked about when I talk to people is they'll have me come over to do a price on their home. And I ask them, if they're separating, I ask them, do you have a separation agreement? And that 99% of times people do not have a separation agreement. They do not understand that if they do not have a separation agreement, they actually can't buy again, because the banks are going to be asking you, are you paying child support? Are you receiving child support? Do you have some clarity around these issues? So they're almost like jumping the gun by calling us first to get a price when they're not 100% ready to go. Are you finding that people don't understand that they need a separation agreement in order to buy again?
Yeah, definitely. So to go through the process of, where you might get to this situation is, yes, if you and your ex-partner, if you've agreed to sell a property, great, you can do that. But without the separation agreement, if you haven't agreed on what's happening, one, as you've mentioned, just to get the approval for financing, they're going to require it. A big reason on top of what you've mentioned why they require it is because if you don't have the separation agreement, we can close the transaction, but you still need to agree on who's getting what. Like that money sits in trust with the lawyer until you both have agreed on who is getting what amount of money.
Oh yeah, that's an even bigger point.
Yeah.
Maybe
And
they're
you
just
need
going to
that
go
money.
rent.
Yeah.
Maybe they're just going to go rent. They don't realize you're freezing that money. Like you
Yeah.
may agree to give them first and last month's rent or whatever from that amount. You can have an agreement that they can have so much money, but
only if both
parties agree.
Parties agree.
Yeah.
And unfortunately, in separations, you may have a very vindictive partner that wants to have there be pain, and they will say, no, I'm not letting any of the money be released until you give me what I want.
right.
And so if you're trying to buy, of course, you're going to most likely be relying on that money to do the purchase. So not only are you going to have problems with the mortgage, you may just not physically have access to the money.
Right.
So yes, the separation agreement is critical to have in those circumstances. And yeah, what a lot of people end up doing is they say, oh, well, me and my partner, we're agreeable. We know we just want to split it equally and whatnot. But as you've mentioned, you still might need to have the separation agreement. One, because unfortunately, as I get to see a lot, is it may be all great to start, but a lot of the times it doesn't end up that way when we get to closing date. If you have the separation agreement already, you've already agreed on the terms. There's, for you to go back on them now or the partner to go back on them would be, very legally costly to them. But again, circumstances change. And also, even if circumstances don't change, you probably are going to have a lender that wants to see the separation agreement, and they are not going to approve you for financing unless you have shown them that, yeah, my spouse has released the rights to this property. I'm not paying the child support. I'm not paying spousal support, because that all goes into their evaluation of whether you actually qualify for a mortgage.
Right.
So yeah, they're critically important. One thing, just talking about separations that that people may not know, to be clear on, if a lawyer is holding funds in trust for you, by default, it is non-interest bearing. And some of these I hold in my trust account for 2-3 years because
What?
they just, and these are ones where they haven't planned to buy, but they've said, okay, we need to sell the house.
Right.
We'll get a partial release, like you were saying, like 10,000-20,000 each, and then we're going to go to court over this.
Right.
And so something like that takes, sometimes 2-3 years. And if you have, $400,000 non-interest bearing, you're losing out on a lot of interest. So just so that you are aware, you can ask your lawyer to invest the funds. Now, they may have a legal or admin fee to do that, but if you anticipate this being a long-term issue, definitely be asking your lawyer about those options.
Again, you have to get permission from both sides. So
Yes, exactly. Yeah, you have to have permission, and it's going to have to be a mutual agreement, but that can be thousands and thousands of dollars of interest. And often your lawyer, because your lawyer probably doesn't know for the real estate side how long this is going to actually take. They don't know if they're going to be holding these funds for 2 weeks or 2 years. So they may not be directly offering this interest-bearing account to you. So again, just it's important for you to know that it is an option, and ask your lawyer if they're not prompting you about that.
Right. What about the power of attorney? So what happens if someone can't make a decision on their own? Well, let's talk about if somebody dies first, because that's obviously the power of attorney is going to come into play there first, right?
So if somebody dies, it's not actually the power of attorney; it's the executor.
Right.
Yeah. So in circumstances where, first off, if there is let's say a husband and wife on title, in most cases, they're on title as what's called joint tenants. So if one of them passes, it actually passes outside of the estate. So the survivor becomes the whole owner, and they can just deal with the property.
Right.
But when that's not the case, if we have two people on title and they haven't taken it that way, then yes, if one passes, their estate needs to be probated. They have to go to court, get an executor, and then that executor is dealing with it. Ideally, they'll have had a will, so it's clear who that executor is. But until that's done, that property, that percentage can't be dealt with. So that is the importance of having your will, for example, because you get to then decide who your executor is and ultimately who inherits.
Right.
The power of attorney is what is called a living document. So that's giving somebody the authority to act on your behalf.
Right.
And in real estate, the most critical time for that is when somebody unfortunately has lost their capacity to act. Because if you don't have the power of attorney already, saying, your wife or your husband is most common,
Right.
Can act on my behalf. If you're 50-50 owners and you lose your capacity, the partner that still has capacity has to go get a guardianship order. They have to go to court to be approved as the guardian,
Right.
even though they're your spouse. And so you can't deal with that property until you have that.
Right.
Yeah.
What would you say, in your opinion, the percentage of people that are adults that own property that don't have a will? Is it kind of shocking to you at how many people don't have a will?
Yeah. So I, especially with first-time buyers, I always ask every single time if they have wills and powers of attorney. And in that case, I would say 95% of people don't, which is more understandable because they're first-time buyers. And so I'm stressing the extreme importance of especially the power of attorney. But then, even when I have people who are buying and selling their fourth or fifth home, I'm still asking them these questions. And
It's relevant.
yeah, I would still say, I don't know, it's going to be somewhere, don't quote me on it, but 60 or 70% of people don't have, some will have wills, but a lot of them don't have the powers of attorney, which honestly for the property ownership is
Probably more
arguably
important.
more important because of the situations that I've seen. Like, tell you a little story about one client. Feel really bad for these individuals. It was an elderly couple, and they had, their realtor at the time that they did they were doing a purchase and sale, so they were going to sell their house, move into somewhere smaller. At the time, the realtor thought that the husband had capacity. They didn't have powers of attorney. By the time they came to meet with me, like a week before closing, I met with them both. The husband, he couldn't remember how many kids he had. He couldn't remember their names. Didn't know where he lived. I couldn't establish anything close to capacity. And unfortunately, what that means is I can't have him sign the documents to sell his house, which means I can't get the money to get their buy. They didn't have powers of attorney. So in this instance, they had to go get a guardianship order. The court would not grant it on an emergency basis. This was over a year ago. The wife still doesn't have guardianship because of complications with their circumstances. So they lost their deposit.
Somebody else didn't get to close on their house.
Somebody else didn't get to close. And so they're still in that same house, and they're paying thousands of dollars in legal fees because this is a complicated guardianship order. You pay a lawyer a lot of money to do that.
Right.
And that all of it could have been avoided if they just had powers of attorney from when they had capacity to sign them.
Right.
And it's like a 2-page document. So they're critically important. And so, when your lawyer suggests that you do one when you're buying a house, take the time. Like, I know the will and power, it's not fun to think about. It's
right. No, it's terrible to think about.
Yeah,
even when I go to meet with a client, I'm always asking them.
Yeah.
I always ask them, do you have children? Like, I want to know if you're like over 80 and you're fine, but I still want to know if there's anybody else that you can count on, you can trust to support you through the process. It's a big deal selling your house.
Yeah.
Right?
Yeah, absolutely.
And how do we know as realtors, like, is there signs that we should be aware of that somebody may not have capacity? Or is that like a really fine, tricky line? Like, I don't want to end up one day like your clients.
Yeah, it is a fine, tricky line. And the unfortunate thing is that with, diseases like dementia and Alzheimer's, these things can accelerate really fast. So it may be in my case that when the realtor did all the agreements, the husband was fine. That's very possible. Right. And so, the main things that, when I'm doing a meeting and I'm taking extra caution, one, it's very elderly clients. That's just the reality of being that age. And then two, just their awareness of, what finances they have. Do they understand, the bank accounts that they have, the money they have? Do they understand what's happening with the property? Do they get that this means, when usually they're selling if they're elderly. So do they understand they're never going to be at this property anymore? Do they know what children they have? Right. Those sorts of things are what, if we sense any, flag with respect to capacity, those are the kinds of things we're evaluating. But what I would recommend to realtors also is, especially when dealing with elderly clients, asking them if they have powers of attorney, and then asking them to give to show you the power of attorney from the outset. If you're not certain on what it means, send it to a lawyer. Send it to me. I'm happy to take a look at it because there can be restrictions, conditions, like on when the power of attorney can be used. So they're not all exactly the same.
So, Jason, can you just tell us the difference between the power of attorney for medical that's required and for property?
There's for personal care, which would be for,
Right.
medical decisions and whatnot. And then, as you mentioned, for property. So dealing with mortgages or properties, bank accounts, and they're usually a separate document. So it is usually they get executed together. So almost anyone that has a power of attorney has both, but technically you could have one and not the other as well.
Okay, good.
Yeah.
And earlier we were talking about you had a friend who wanted to purchase a cottage and bought into half of a cottage and didn't actually get any legal advice. Can you tell us a little bit about that story and what happened?
Yeah, that was a not a fun one. So it was a client. I didn't know them, but what had ended up happening was, so the story of them first is it was this older couple who had a cottage on the same road as these people that they became good friends with.
Right.
The friends of the cottage in question, it was a daughter and some parents that owned the property. The parents who were my clients who were friends with, they ended up having some health issues, wanted to get off title. So my clients wanted to sell their cottage so that they could buy half of the cottage and own it with the daughter.
Right.
And on its own, that's already very complicated and there's a lot of red flags there. But what they ended up doing is they ended up negotiating this entirely by themselves, no legal representation, no realtors involved. And so they were just going to go on title with 50%. And so they entered into a completely firm agreement, no conditions, big deposit. I think it was around 5%. I think it was about 40, 50K. And they had this provision in there that they were going to live in the property for 1 week before closing. But it just said we have the right to live here for this 1 week. It didn't say anything about, a condition on whether it didn't go well.
Right.
So they lived at this property for the week and realized, oh, this is a terrible idea. We can't, we have big problems with these people. We can't live here. We don't want to proceed.
Right.
So they, asked, okay, we want to kill this deal. We don't want to proceed anymore. The seller said, no, we're proceeding. Too bad, so sad. And it's a firm agreement, so our clients were bound by it. They didn't close, and this, I believe, again, I don't do the litigation side, but I believe it's still in litigation because...
So not only did they lose their deposit, then they were sued for not closing.
Well, the deposit's still in the deposit's still in trust, but they're litigating over whether that should be released entirely to the seller, which in most cases it will be.
It will be.
And then they're going to be potentially sued for more if their losses exceeds the 50K.
Right.
And then, if they had just spoken to a realtor or a lawyer before, they would have been advised that, hey, this is probably this is not a standard way of doing this, and there's a lot of problems that can arise.
Right.
But also, if they still insisted that they were going to do it, could have at least put in a conditional period and done that properly so that it was conditional upon them living there and that being to their satisfaction.
Right.
Because if that conditional period was in there and they didn't want to proceed, well, then they have the right to get their deposit back, cancel the deal, and walk away from this.
Right. So if it's too good to be true, it usually is. That's a good lesson.
And also, unfortunately, when money's involved, it doesn't matter who you're dealing with. If they're friends for 30 years, you start to involve money, and unfortunately, I get to see the worst of people when that happens. So it's not always just straightforward. Everything's going to go well. You still, even if you're dealing with your best friend, if you're dealing with a lot of money, you probably want to get some advice on how it's going to work and the best way to work it.
The structure.
Yeah.
That's right. Okay. Yeah. There's a lot of talk in the media right now about tenants, landlords, who has rights, who doesn't have rights, how unfair it is for landlords. Can you just talk a little bit about your background with dealing with tenants and landlords, and what kind of things are you seeing on the ground?
Yeah, for sure. So you're right. There's a lot of rights that tenants have, and in many cases that's fair, but that puts a lot of burden on the landlord as well. So when we're dealing with properties, a complicating factor is we have a landlord seller who has these tenants in the property, and even if they're selling to somebody that wants to buy the property and live there, well, you still have these tenants there, and you have to somehow get them out. Now there is a process to do that, a legal process through the landlord tenant board and whatnot, but the reality is you have these people physically in the house, and to get them physically out can be very complicated if they're resistant to that.
Right.
So, the main thing for buyers, for example, is understanding what it means when you're buying a property that currently has tenants. The first thing is if you're a buyer and you are wanting to buy a property either as an investment property or a rental, you need to understand that that tenant has no obligation to get out of the property. That you have to, if you want to proceed, you have to take that tenancy on its current terms. So you can't charge them more, like start a whole new tenancy. They have the right to remain at the property.
Right.
The only circumstance where the tenant can be forced to leave, or the only practical circumstance, is if you as a buyer intend to live there, or a close relation like a parents or children intend to live there as a principal residence.
Right. But that doesn't mean when you get there on closing date that's the reality, that they've actually moved out.
Exactly.
So how do we protect them as realtors? How do we protect our client from that situation?
Yeah. So there's no complete foolproof way to do that.
Thought that you say that.
When we have buyers and they want to be able to close, on the closing date, of course, and there is the tenants that are at the property, one of the best things that they can do from the perspective of the contract is to have a requirement that the seller is keeping them apprised of the process of getting the tenants out. The main thing that looks like is requiring that by a certain time they have shown that the tenant has signed the appropriate documentation.
Which would be like a mutual release?
Exactly, like a mutual agreement, which is called an N11, which is where the tenant agrees, yes, we're gonna get out.
Right.
That's the best case scenario for a buyer, because you see, okay, the tenant clearly has agreed to get out. This isn't the tenant resisting. They've signed. They understand they're leaving.
So let's say they've signed the N11, and then it's closing date, and they're still there. Does the new buyer just not close on that property because the tenant's not gone, or what happens next?
Yeah, so that's up to the buyer, because yes, if the tenant's still there, the buyer's negotiated for what's called vacant possession of the property. They're entitled to receive that if that's how the contract is structured, and so the seller is unable to provide that. So from the buyer's perspective, one, they're allowed to say, you haven't been able to give me what we bargained for on the closing date, so I'm not proceeding with the transaction. I want my deposit back. That's one option. The other is to extend the transaction and understand, okay, you're going to need another month to get this tenant out. I'll give you that, but I want my usually opportunity cost covered, or some sort of cost for the fact that they don't have this yet. The other, which is not advisable, is for you to assume the tenant and do the eviction process yourself. Some clients I've had do this and insist upon it because maybe it's a 2-unit and they just want to use it as a whole house,
right?
But they know they can live in the upstairs and just deal with the basement tenant later. But even that, like say, if I don't advise doing that, because now you're just inheriting all the complications and issues with doing that. And you don't even know how long, like the landlord tenant board, you have no idea how long an eviction process is going to take.
Right. And some of these tenants they've been doing this a long time. This is not their first time not paying rent.
Yeah.
I'm not saying that all tenants are like that. Sometimes people just fall in hard times, but it is suspect that similar people keep having the same problems, right? So
yeah. And then sometimes when you have a tenant who understands the system and is abusing it in that way, like you said, it's not the first rodeo. They've done this before. They know how to delay the process, and it can take months or technically years.
I don't know how people can live with themselves doing that to people. I've seen people just be so upset and beside themselves, the stress of not being able to, sleep at night, because now they've got to come figure out a way to pay their mortgage, and they can't. Without that income, they literally are losing everything. Yeah.
No, it's really sad for a lot of people, and that's where you can provision for that, like with the advice of your realtor, with the advice of your lawyer, to mitigate that risk as much as possible.
Yeah, I would hope people that have an investment property have enough money in that property to get it refinanced, to pull that money out anyways if somebody's not paying. But still, that shouldn't be their landlord's obligation, right? But still, I hope that people who do that are not skating on the edge and don't have a lot of equity in those properties that they're purchasing. And maybe the thing is they shouldn't be. you know, purchasing properties if they don't have enough equity
Yeah.
to support themselves. So, yeah. Okay. So let's do rapid fire. Okay, Jason? Biggest mistake the buyers make?
I would say the biggest mistake buyers make, I'm going to make this for people that are buying and selling.
Okay.
And that is buying and selling on the same day. I know sometimes that is not, it's only the only possible way. If you have any ability to not buy and sell on the same day, go get a bridge loan and you will save yourself a bunch of stress and anxiety. Again, most of the time buying and selling on the same day is fine, but if there is an issue, it's in those transactions. And what happens is, you know, if you are selling to buy, the person buying your property, they might have an issue,
Right.
can't pay you, and now you can't pay your seller. So you may have moved out of your property at 12 p.m. You've been in a moving truck since then waiting. It's now 6 p.m. You're still there, and I can't close your transaction because I don't have the money from your sale yet.
Right.
You got to figure out what you're going to do with this moving truck. You now have a seller who could note you in breach of your contract and relist and resell, and you have no new house.
Right.
These are all technically possible. Again, it doesn't normally happen that way, but the bridge loan just avoids all that. It's, in my opinion, completely worth the cost if you have the ability to get it.
Okay, good. That's actually a good, because people will ask me, and I know that there's some challenges with closing on the same day, obviously, but there's also, some people don't want to pay the bridge financing, but it's not as expensive as it used to be.
No,
for sure.
it's costly, but it's not out of this world. It's, you know, it usually for the standard bridge loan, it depends on the amount that is outstanding, but 100 to 150 a day is the most common that I see for bridge financing.
Right.
Yeah.
Okay. Biggest mistake that sellers make?
The biggest mistake that I frequently see sellers make is they haven't told their realtor, or their realtor hasn't asked them whether there are rental items at the property. So the problem with that is if you don't note rentals in the agreement of purchase and sale, the buyer can require that you buy out the contract because you basically represented that it was an owned item. So the most common that I see are hot water tanks and furnaces.
Right.
Specifically, if you don't note that a furnace is a rental, you might be responsible for a $10,000, $15,000 buyout.
Right.
So I see this quite frequently. So one, for realtors who are watching, stress to your clients the importance of making sure they do not have any rentals. And for clients, you know, make sure you're disclosing this or telling this to your realtor because it can cost you a lot of money.
Right. It's interesting because some people, they can actually afford to pay for their hot water tank or their furnace, but they're being convinced that the best way to go is to rent it. So they've got a plan and they've got insurance. And I'm like, no, that's like now it's like 15,000 instead of 5,000. So call your realtor first. We usually can get you a better price anyways. And we will kind of give you that instruction of what to do. But now we're trying to be really safe when it comes to rentals, because we know that even though people say, oh, my furnace is 2022, do you own it?
Yeah.
Right? So we are asking those questions.
And there's a lot of people who think they do, and if they do a little more digging, they don't actually.
Right. Usually there's a sticker on their rental, their hot water tank, or even their furnace that says it's a rental. So look for the sticker.
Yes.
Yeah.
Exactly.
Most overlooked cost in real estate?
Yeah, so there's a few costs that frequently I find that, we'll start with buyers. For buyers, they often are not aware of the title insurance costs, as we talked about a bit before. So title insurance it's based on the price, but normally it's going to be between $700 and $1,200 for people. So that's often an unexpected cost. And also property taxes. So there's always an adjustment for property tax. Depending on the time of year, the seller may have already paid all the property tax.
Right.
And you need to credit them back for the time they've paid for you. So while it does mean, of course, you don't need to pay property tax for the rest of the year, if you're buying a property over $1 million in Oshawa and it's September, the sellers probably have already paid. You probably need to pay them $1,000 to $2,000 back in property tax, and you just may not have anticipated that.
And the interesting part was when you're a first-time buyer, you're like counting all your pennies.
Exactly.
So these are pennies that you haven't counted. So with us, we actually do a buyer consult where we're walking people through the extra costs that they might have when they're closing, because you don't want to be skating on the edge with only your 5% down. You definitely want to have your closing costs in hand as well.
Yeah, absolutely.
Yeah.
And then just one more thing for sellers. One thing I find that, again, reasonably frequently they're not aware of is the commission on real estate the HST on real estate commission.
It's now in our contract that they know that they're paying HST in the seller's side. It wasn't before. This is brand new. It'll say, here's your percent. We always put 5 plus HST.
Yeah.
And now there's a separate section that says there's HST on the commission.
Yeah.
Which, I don't blame people for being mad at that. That's like sometimes like $3,500 or more.
Yeah, or more. Yeah. So it comes as a price because I end up showing them the commission statement and like what they're going to get out of the transaction. And there's a lot of clients that are surprised that this.
They should not be surprised. Yes. Yeah. I'm mad that they're surprised because they should not be surprised.
Yeah. No, that's what I frequently see though.
Right. One legal term people should understand.
We talked about it a little bit before, but you might hear caveat emptor or buyer beware get thrown around when we're talking about real estate, and it really just means buyer beware. It's as is. If you don't do your inspection or your due diligence, if something is wrong with the property, in all likelihood, you're not going to have a great claim against the seller.
Right.
And so that's like the legal terminology that you might hear somebody reference, and that's what it means.
Right. Well, in a fast market, we're recommending that people do pre-inspections before. You might pay $400 or $500 for the inspection, but now you go into the multiple offers with knowing what their issues are. You can account for that in your purchase price, right? Yeah. So we're recommending that people do that, but some people they just want to go.
Yeah, don't want to pay the cost for it.
Yeah, they don't because if they lose, they've just paid $400
it feels
for their
like
home inspection.
completely wasted money, but it's
bring Uncle Sam with you. Bring somebody that's qualified, somewhat qualified to help you out. Yeah. Firm offer or conditional offer?
Yeah, I mean, from my perspective, if it's at all possible, always like from a buyer's perspective, conditional. And I understand that practically speaking, sometimes the market doesn't allow a competitive offer that has a condition. But the condition for financing or home inspection, it's always going to be a benefit to you as a buyer.
Right.
There's no way the seller can use that conditional period to get out of the transaction. It's only to your benefit as the buyer.
Right.
So if you can negotiate that into your offer, it's really important that you have it.
Well, I think also from my perspective, a lot of people think they're pre-approved for financing, but they haven't given their paperwork in. They haven't given their credit scores. They haven't given their income statements. So if you haven't done all that, your bank has not pre-approved you.
Exactly.
So make sure you've given all of that information.
Yeah.
Right?
Yeah. The pre-approval almost always is just you've told the bank these things, like you've written it down.
And they've not verified. No problem.
Exactly. They've not verified any of it. They also haven't verified it to the property you're looking to buy. They've just said, well, you qualify for this. Mm-hmm. They haven't looked at the actual property. Like they need to see the agreement of purchase and sale, what you're actually buying before they will give you an official approval, like a full commitment.
Right.
So you can't have that really until you have the agreement technically.
Agreement purchase and sale. And they want the MLS listing because they want to look at the actual listing to make sure it's valid. Right?
Exactly.
Yeah. Craziest deal you've ever seen? This should be good.
Oh, yeah. Well, we talked about a few crazy ones today, but...
Is there another crazy one?
Oh, yeah, there's lots of crazy
ones.
ones.
Isn't really rapid fire.
Yeah. No, a crazy one that I had recently that is coming immediately to mind is... it's a sad one, unfortunately. Usually the crazy ones are a little sad. But I had a father who was selling his house... and he had his own mortgage on it, and had that been the only thing, he was supposed to get about $200,000 would have been ultimately what he would have received. Mm-hmm. Unfortunately, he had a son who had used his line of credit, who had taken out loans in his car loans, et cetera, in his dad's name, which formed liens on the property. And so I had to be the one to tell this client that, no, you're not getting $200,000. You owe me $8,000. Otherwise, I cannot close this transaction because I don't have enough money to pay all these liens off. And so obviously that was devastating for the father. Luckily, he was able to get the money so he could complete the transaction, be clear of these things. It was crazy because the son would have had to have access to IDs and whatnot for dad. So it was crazy that all of this was on there, and it's all in his name. So because he's saying no to me, he's saying no, none of this is mine. I shouldn't be paying for this.
Right.
I'm sorry, but It's all in your name. It's registered on title to your property. I can't close this transaction for you unless we elect to pay these off.
So many devastating
Yeah.
issues for people.
So,
right?
like I say, luckily he was able to at least close, because if you can't close, I mean, you lose the transaction, and now you just have to deal with all of that, and you still owe all the money, right? And so now it's a matter of pursuing his own son for the fraudulent activity. It was a crazy one to deal with. Luckily, again, we were able to get it done, but it's unfortunately not the end of the road for him.
For that, okay.
I got a lot of crazy ones. We had this transaction where I was acting for a buyer, and everything's standard there. They were going to buy this property, and the property had a mortgage on it, which is completely normal. When that's the case, what happens is the seller's lawyer, they give their promise to pay off the mortgage. So the buyer's lawyer, we give the money to the seller's lawyer. They go and do the discharge. We have title to the property. In this case, we did all that. We closed. My client's now the owner of the property. About 3 months goes by, and my client gets notice from a lender that, hey, this mortgage is in default. We're going to take this property power of sale. And it's not my client's mortgage. So we look, and the lawyer never discharged the mortgage. So we're like, okay, that's weird. We find out that what the lawyer did is, instead of paying off the mortgage, they took the funds and they ended up fleeing to Russia. And they did this on multiple transactions all at once.
This isn't just one transaction.
Yeah. So they pooled up a bunch and did this. So, that leaves my client with a $300,000 mortgage outstanding on their property. And so, luckily, and in most cases now people have title insurance, but title insurance actually stepped in this case, literally just paid off the mortgage. And then they are the ones that do all the litigation to confirm, well, this was a fraudulent mortgage. This individual should not have been responsible for this. But so our client doesn't have to do any of that. They just pay it off, get rid of it. And again, because that lawyer's in Russia, there's a whole big, law pro claim, legal insurance that the title insurer will now claim, instead of the client, again, having to go through all those hoops and stress and anxiety of doing that. But for me, that's still, title insurer wants to know why they have to pay $300,000 and what happened, what went wrong. And again, we did everything correctly. What we have to do on all transactions is rely on a seller's undertaking, it's their professional responsibility as a lawyer. We're relying on them as a lawyer. It was pretty crazy to deal with, and of course explain to a client the circumstances. But at the end of the day, the client didn't really have to do anything, so they were in a good spot. But it was a wild couple weeks.
Thank God for title insurance, because I've heard a lot of complaints. People are like, what do I need to pay that for? Yeah. Wow, and you've given me some good stories today to
it's
back
very valuable to have, and you pay for it the one time. There's no monthly premium or anything, and you have it anyway for the whole time you own that property.
Right. One thing you should always double check.
Well, what I'm always double checking when I'm doing a transaction is, I'm always double checking IDs.
Right.
So I'm double checking to make sure that people who they say they are, because unfortunately fraud is a pretty common occurrence.
Right.
And then I'm also, of course, double checking, if I'm dealing with a selling client, oftentimes they don't want to deliver me a physical void check or direct deposit form to give them money. So they're emailing it to me. So I'm double checking to make sure, yes, you actually emailed me, this is yours. This is the account I'm putting this into.
Right.
And so in the same vein, I would suggest to people to double check, one, to make sure if you're selling that you're giving the lawyer the right information, and that you're verifying that they have in fact received that information. So for example, verify that someone hasn't hacked your account and given a fake account to the lawyer. Make sure that they have the correct information.
Right. I heard a situation, I haven't heard it recently, but last year at some time, where people were getting emails from lawyers saying, you need to send me blank, and they were doing that. Have you heard anything about that or no?
Yeah. So there have been, law firms that have been hacked, and so they'll and that's why you want to be double checking these things, because technically it's possible where you have a lawyer say, I need you to send me this, or we're changing this. The most common thing that happens when lawyers get hacked is that they have somebody else, like a different email, fake email or something, say, hey, I'm the client. I actually want the funds to go into this account.
Right.
And it's a fake account.
Right.
And that's, again, where I'm doing my due diligence to make sure I'm communicating with my client and not a fraudulent individual.
Right. Well, you should always, even if you get something from the CRA or your Royal Bank, if you're not sure, don't click on a link. If you're not expecting anything, don't click on a link.
Yeah.
And same thing with if your lawyer hasn't told you, you need to transfer me $200,000, don't transfer $200,000 from an email.
Yeah,
correct?
absolutely.
Yeah.
Yeah.
Because you're never going to tell somebody to transfer that through an email system. You're always going to have
exactly. That's the thing, is if there's a transfer that doesn't make any sense, it has nothing to do with the transaction, or they're just asking you to pay things which doesn't make a whole lot of sense. Talk, get them on the phone or go into the office.
Right.
Make sure it's legitimate, because just like any other organization, like you see, Fortune 500 companies get hacked, and
fraud is prevalent.
So it happens to law firms too.
Right.
Be double checking, be diligent with that, because technically it can happen. Yeah.
Okay. Well, thank you very much, Jason. That was amazing. Thanks for coming in today.
No, it was great to come in. I had a really good time speaking with you, and hopefully, can do it again sometime.
Yeah. So. And the one thing is, I just like people to take one thing away from today. So if we added value to someone, that's what this podcast is all about.
Yeah, absolutely. Yeah. I completely agree.
Great.
Yeah.
If you're buying or selling, having the right team matters, and that includes your lawyer. We'll drop all of Jason's info in the show notes. Thanks for listening. And if you found this helpful, send it to someone who's thinking about making a move this year. Talk soon.